On the 25th of June 2024, a member of Fonterra's government affairs team sends an email to Matt Burgess, who is Christopher Luxon's chief policy advisor. But despite this being a formal communication between a member of Fonterra's government affairs team and the sitting chief policy advisor to the Prime Minister, they used his personal email. That email says that this is a 2-sentence legislative amendment that Fonterra believes will resolve the uncertainty and risks posed by private law claims like Mr. Smith's. Plain terms, these 2 sentences say nobody can use tort or equity to ask a court for any remedy against any greenhouse emitter for climate effects. And then the second sentence applies the ban retrospectively, making sure to catch Smith's case. The polluters call this balance, but this wording was deliberately and specifically designed to stop Smith's active case. It protects any person, which means companies and potentially the Crown, and it prevents not only damages but declarations, injunctions and other equitable relief. So these big polluters didn't just send the government a vague policy suggestion or their thoughts for consideration. They provided Goldsmith with complete statutory clauses expressively killing Smith versus Fonterra. So Fonterra wrote the addendum to the law that kills the case against them. These cronies actually went further than even the industrialists had suggested to them. The version that made it into the Act is actually even broader and more technically developed. They added explicit protection for the Crown, the British Crown. They carved out actual or potential contributions to emissions, activity and harm outside or inside New Zealand, supply chain and related party activity, an explicit reference to Smith v Fonterra, and a clause denying compensation. So the polluters provided the first draft, and these cronies expanded it, making it technically harder to evade and explicitly attaching it to Mike Smith's case.